Live. Guru Nation. We got 56 minutes to get right into it. This is not a fraud pod. This is
No.
not an after dark. Okay. Those are all separate. They're going to keep coming at you. Obviously, it's not dark if you're watching live. You can see that. Unless you're on the other side of the world, then it's after dark for you. My bad. My bad. Listen, we got Darshan Kulkarni. We got something brand new to announce. We're bringing back our old Site Owner Academy due to popular demand. It got really popular in the beginning. Then we stopped promoting it as much and we started just saying, hey, you know what? You want to own a site? You should do the CRC Academy. But now, because of Darshan, he's joining our team. We're doing a Site Owner Academy again, 5 weeks, practical. The 5 weeks, we're going to tell you guys from the practical side, like you need to do this, and this to actually get your site up and running and make money. And then we have Darshan who's going to come in and say, well, yeah, but this is how you're going to stay compliant and this is what you should do. So it's going to be like a good balance of like gas, brake, right? Gas,
Yeah.
brake.
Hopefully it can be the clutch as well.
The clutch. Man, for those that don't know how to drive manual, good luck. Good luck.
And that's when you bring in the lawyer to be the clutch, because you don't have to be the clutch for everything.
I like that. You don't have to be the clutch, and we hope this is like a good way for people who are serious about owning sites, because it's not like an affordable product necessarily, but if you're serious about, and that's part of the filtering out, we've got free content if you want to own a site.
Yeah.
But if you want to like act like it's gonna be like
Well,
weekly meetups with
yeah.
Darshan and the team and like super in-depth stuff, and then hopefully it's a launching pad to like start your relationship with Darshan or maybe with me and Chris on the business development stuff. So anyways, it's not for everyone, not for the masses, but on this video, this is for the masses. Look, I have in front of me, which I'm obviously not going to share the screen because that would be nuclear, but it's a real contract I have with a sponsor, a really good study too, and a really big pharma company. And we're going to go through the CTA. And again, we only have like 50 minutes maybe. We're going to get through as much as we can. It's 15 pages. But the last 4 are really like the budget and that, we're not going to get into that. Where we're going to get into the language of stuff because we got an attorney on and not legal advice, right? I guess
Yes.
we got to
And
make
not
that
clinical
disclaimer.
advice. And not
Yeah.
regulatory advice.
Really
This
not
is for
any kind of
educational
advice
purposes only.
or entertainment.
Yes.
And I wish I could share the screen, but again, that would probably be nuclear. So I won't do that. But here's a CTA in front of me, Darshan. You can't see it, but I will just go through the sections. Okay, so investigator and institution obligations. This is like probably
Actually, let's start from before then.
before that it says yeah,
Who are
what
the signatories? Who are the parties?
okay. Yuma Clinical Trials, the sponsor.
Okay, so let's start with that first part.
And
Why
its
Yuma Clinical Trials?
institution shall provide the services of its employee RPI.
Okay, so few different pieces that come into play right here.
Already. This is
Exactly. This is the first line.
this is the part we skip, but okay, this is why you're here.
So this is the conversation you and I had in the last After Dark, where we talked about who should be the signatory. The signatory, if you can help it, depending on where you are, if you're a site owner, should be the organization that does the research. Depending on what kind of research you're doing, that won't be the doctor's office. So you have to look at structuring it so that only the organization that does the research is signing the paperwork. Now, that's not always possible because each state will have its own laws that says that depending on what you're doing, only the doctor's office can sign. Or what you'll often see is the doctor will acknowledge, but the site will sign. You've got to make sure you've understood whether you're engaged in the corporate practice of medicine and how you're going to split up the party that signs.
So
So
the signing, I'm looking at it now, and this is like over a year ago. Well, actually, almost exactly a year ago. Agreed and accepted by me from Yuma
right.
Clinical Trials, and agreed and accepted by investigator.
See, that's a huge problem. I wouldn't say agreed and accepted by the PI because
Damn
he's not
it.
a party.
Hopefully, PI is not watching. He
Because
says, "Dan, I
I'm the
trust you,
PI.
man. Let's do this." And this is actually a good study we made. This is our highest revenue generating study we've had in the
Wow.
3 years that we've done this research.
So if I'm the PI, I don't want to be signing it as agreed and accepted because number one, I never read it. What am I agreeing and accepting to? I'm not a party to the organization. I'm not. I can say read and acknowledged, but I'm not agreed and accepted.
What's the difference?
So agreed and accepted means you've read the terms, you agree to be bound by the terms. Read and acknowledged is I know this thing exists. I'm not saying it binds me or anything. I'm just saying I know this thing exists.
So that's a first free tip right there.
Right.
Read and acknowledged, not read and accepted.
And
And you
most
think
sponsors
that's
understand that. Oh, this is standard. Most
even if
sponsors
our
do.
PI, in this case, our PI is a part owner of the site.
Now, in that case, now if the PI is part owner of the site, I don't think I don't know why the PI is even signing it because technically he's already bound by it.
Okay. Like he could have signed where I signed, but we
Right.
just wanted like two different
Correct.
signatures.
Correct.
Mhm.
So unless you're saying that signed by the PI in their role as a PI, in which case the point is, do you really need that? You're going to get the 1572 anyways. What is the point of this
That's
section?
what I always say to you. Yeah. So what's the bottom line here? Like, so we can move on.
It all comes down to if your PI is an owner in the site or not. If the PI is an owner, then what you want is the PI. If the PI is an owner, he doesn't need to sign because one of the site owners is going to sign if it's the PI. That's fine. If the PI is not an owner, you're going to do read and acknowledged.
Okay, so that's so for us, because in our case, all of our PIs are owners.
Okay.
Okay, but for those watching, I mean, I know that's not really common. So
And different states will allow, depending on how you've structured it, will allow for that or will not allow for that.
right,
Depending on what organization is being bought. So, for example, in Yuma Clinical Trials, the PI can be an owner. But if Yuma Clinical Trials was a vendor to Dr. Smith's office and Yuma Clinical Trials does research for Dr. Smith's office, who is the signatory body? Is it Dr. Smith's office or is it Yuma Clinical Trials? And depending on how you structure that, Yuma Clinical Trials may not be able to sign, or Dr. Smith may not allow Yuma Clinical Trials to sign. So it gets complicated, but it shouldn't be that complicated. Keep it simple. The contract body, the one that does the research, that's the one that should sign. The PI just read and acknowledge if the if the sponsor really wants it. If not, just take it out. I'm not sure what value it's adding.
okay. So the first section, it's called Roman numeral 1.
Okay.
Because it gets complicated. So like, bear with me. I wish I could show you guys.
Can I add one more thing?
Yeah.
So the doctor, I assume the doctor, if they decide to put the doctor in that introductory section, never, ever, 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 ever sign in your personal capacity. It happens all the time.
Yes.
I love to get people to sign in their personal capacity if I'm a lawyer, because you're putting all your personal assets on the line at that point, because you're in your personal capacity. What you want to say is in my capacity as CEO, whatever, for Yuma Clinical Trials. So then your liability is limited to whatever that organization is.
So the way I signed it here, you're saying if you're a doctor,
Whoever,
okay.
you never in no contract, if you can help it, do you sign in your personal capacity?
So here where I signed, it says agreed and accepted Yuma Clinical Trials, and then it has my signature, authorized official, my printed name, president, because they want title, and the date.
Yeah. So you're signing on behalf of the company. That's what you're doing.
Yep. Okay, I understand. Now it gets complicated because it's a Roman numeral I, or 1, investigator and institution obligations. Then it goes letter A, conduct of the study. Then it goes numbers underneath, compliance with protocol, laws, regulations, export control, sanctions, and then it goes
I take out
small
anything.
letters.
So I pull out export controls. Why do I need to adhere to any export controls? So here there are two schools of thought on this. If I'm negotiating for the sponsor, I go, it doesn't apply to you. Why do you care? If I'm negotiating on behalf of the site, I go, it doesn't apply to me. I don't want it in the contract.
It doesn't apply to me. Why do you care? Same thing.
Yeah, exactly. If
Yeah.
it doesn't apply to me, why do you care?
Uh-huh.
So take out as much as you possibly can. Why does it matter? Because you'll see situations where people will say, "Oh, I want you to comply with international privacy laws." I'm not complying with international privacy laws because those things are complicated. I don't have the resource for it. I shouldn't be complying with anything I'm not signing up for.
Yeah.
But the sponsor is trying to cover their butt, and I don't blame them for doing that. Just get as much coverage as possible.
Yeah. So right away, so you have like the compliance with protocol laws and regulations. Obviously, that
That's fine.
has
Yeah.
to stay in there. There's a big paragraph underneath it. I don't know if you want me to get into it.
If you want.
Investigators shall personally conduct or supervise the study at institution and any sponsor-approved subsites or
Hold
satellite.
on. Let's start that line. Investigators shall what now?
You're already dissect. Investigators shall
Why personally is what I'm trying to understand.
Yeah, investigators shall personally conduct or supervise the study
Okay.
at institution and any sponsor-approved subsites or satellite sites.
Okay.
If applicable, collectively study sites, investigator, and institution shall comply with the following. All conditions, requirements, and written directions specified by sponsor, the protocol, and any amendments and or addenda thereof of applicable
So
requirements.
right here, I would put a note for myself to go back and say, and any amendments. I want to have a clause somewhere that says those amendments shall be negotiated separately. And there needs to be some kind of pricing associated with that because every so often, again, I've written those amendments and those can be onerous. You want to make sure that if there's an amendment, there's a financial thing that goes along with the amendment.
Right. But yeah, and this is where like the legal meets the practical. Like,
Right.
I mean, for the most part, when there's an amendment, if the site is smart, well, first of all, if the sponsor is good, they will fix your budget automatically. Like you'll have to agree to it, but they'll increase,
Larger sponsors will. Smaller sponsors are often, if they don't notice it, let's not raise awareness.
Yeah. So then smart sites, if you're watching this, you are hopefully one, you know that you have power in the form of you have patience. Like that's where you have leverage. Like, hey, we're not okay with this amendment. Like, we're not going to enroll more patients if we don't get, fairly compensated for whatever changes are brought up.
I think, yeah, absolutely.
You want to like a real world example?
Sure, of course.
We had a study, another one recently, say, hey, you know what? They sent an email. They didn't amend the protocol, but they sent an email that said temporarily because of FDA diversity plan, blah, blah, blah.
Mm-hmm.
We need more Hispanic patients. So this was a study-wide email.
So
we're only allowing.
Let's stop it right there.
Yeah.
Right there.
Yeah.
The FDA's rules around diversity plan want you to have a diversity plan. It does not require that you actually have more diverse patients yet. They want you to work towards having more diverse patients. To take the efforts. For example, go to Yuma because you have access to more diverse patients. Right. Doing a study in rural Nebraska is probably not going to get you more Hispanic patients. But you're going to Yuma, you're going to get access. So sponsors who are going, I want more diverse patients, are misunderstanding what the result expected from the diversity programs is.
Fair enough. They might be more conservative, or I mean, I don't know what their thought process. I don't even know who these people are. They're just speaking to their messengers.
Yeah.
But basically, it said, temporarily, we're only allowing one other race for every 3 Hispanics that you enroll.
Which I'm not sure if that's the point of diversity as well. like one other race. So you
It
get
could get racist, like
no, but what about an African American? Like that's not diverse,
exactly.
certainly, and
No,
Asian's not diverse, and
not according to this email.
that's
Not according to this email. I even had a talk with my team. Like,
yeah,
we're not in a part of the country where there are a lot of African
sure,
Americans. We do have
sure,
some in our trials.
yeah.
It's less likely to be an issue at our site because we do have the Hispanics, but like at a site in
In Philadelphia and
Mississippi,
Memphis and wherever you're
yeah,
gonna, yeah,
yeah. If you're on this study as a site and you found an African American person that qualifies and you tell them, hey, we just got an email that
you aren't diverse enough for us.
we can't enroll you because of your race.
Yeah,
Like, that's not gonna go very well.
that's not a smart move.
Right. But the point is that wasn't an amendment to
Right.
bring it back to this topic.
Yeah,
That wasn't an amendment. That was just a sponsor mandate. We went back and said, hey, we need to fix our budget. And then now
yeah,
Chris is working with them on what we can get. Probably a couple extra $1,000 for like some outreach stuff. But
yeah.
point is you have some leverage as a site, especially if you have access to the patients that they want.
I also would argue that that makes your site more valuable. So my point being, what is fair market value at a point when you are
Mm,
bringing in a different set of patients, of subjects that they can't get access to? I don't want to use the word patients. Whenever I do, I mean subjects, but or
yeah.
participants, depending on who you're talking to.
We call them patients, but yeah, I get you.
Well, I avoid patients for the same reason. We don't want to get into the corporate practice of medicine. If
No,
you are
I know.
corporate,
Yeah.
exactly. But anyway, so the point we were making was, um, I wonder, and I don't know the answer to this question. No one does. Um, what is fair market value for a site that has the population that the FDA is expecting, or FDA expects you to look out for, when other sites don't have it? And I argue that there might be
Yeah.
more than just a marketing
Yeah.
budget, if you
If
will.
they want, I love that you're giving me more ammo and Chris really for the budget negotiations. If you want to talk fair market value, bring it up.
Right.
And I'll reference this email even for other sponsors and say, look, what's going to happen when 9 months in you send me an email like this?
Right.
Right? That's okay. So, all right, let's get back to the contract. We're still under like the first section, investigator and
Yeah,
institutional
20 minutes in, we haven't even gotten past section
This
one.
court, you guys, I'm telling you, if you're serious about starting a site or you already have a startup, you might want to consider message me.
Yeah.
So export control regulation, you said take it out. Sanctions,
Or explain to me why you think it should be in there.
I don't think it should be in there.
And that's my point. So you
I
tell
never
me.
I never read this, Darshan. Chris did
Yeah,
this. You know, Chris focuses a lot on the budget
right.
and the CTAs. We all feel as site owners, and this is why we need you to help with our academy. We all feel like these are just templates. There's not much you can do. Maybe some
Oh,
indemnification, and that's
we
it, right?
negotiated the crap out of those.
I know that's where you come in because you're like the expert on this side. So we're all constantly improving, man.
Yep, absolutely. You absolutely all are.
Uh, Next section is sanctions. Investigator and institution represent and warrants that neither investigator, institution, and to the best of their knowledge, its directors, executive officers, agents, shareholders, nor any
Mhm.
person having a controlling interest in institution are a person targeted by trade or financial sanctions.
Let's stop right there because I'll sort of do the whole
I mean,
discussion
this
here.
stuff never applies to us, but there's people out there.
Oh,
Maybe it is.
well, I've been involved in sites where this has been a huge issue.
Okay,
A huge issue. It shut down sites.
this could be a 12-hour live stream.
At the Magi conference, we do this as an 8-hour discussion.
Darshan, you shall not mention competing conferences on the show ever again. Okay? Please, you're SOS now, Team SOS.
You can still be Team SOS, but anyways, the point being, there are conferences where this is an 8-hour presentation, and they've done that version of it for multiple years. Like I want to say, like 7 to 8 years, if not longer.
Mhm.
And we always just touch the surface. There's so many variations, and we aren't discussing these variations. We're only talking about this variant right here. So keep that in mind as well.
Okay. A person
So I'm sorry. We didn't get to the point here. The point here was
sanctions.
sanctions. So what happens is there are different types of sanctions. There's one that is directed to residents. There's one that's directed to HHS. There's one that's directed to FDA. As part of a compliance program from the DOJ, what you should be having is a process to evaluate whether your program is compliant. And that involves doing maybe annual checks, and every new employee gets checked every time they get onboarded to make sure that they do not fall into any of these exclusion lists.
Yeah. So it's section like under sanctions, right?
Yeah.
A is person or targeted by trade or financial sanctions under UN, US,
Yeah.
EU. But the one that's interesting to me in light of recent consolidation, like merger and acquisition trend, I mean, you go to investigator meeting now, half of the sites are owned by some PE company, right?
Right.
So section C under sanctions is directly or indirectly owned or controlled by such persons. Together, restricted person. If your site is owned or partially owned by a PE, you actually may not know who ultimately is at the top of that pyramid,
That's
right?
the point. When you're being acquired, do you find out, look, are you guys excluded? What compliance program do you have?
Right.
Because now you get to increase the value of your site, because you get to go, look, I need to know that you guys have a compliance program that doesn't screw me if I become part of your site network.
So if you're a site that's thinking of getting acquired, do you ask this stuff?
Absolutely. Absolutely.
At what part of the process? Like,
So what you'd end up doing is, I just want to know what kind of compliance program you guys have, because I'm certifying in all of my clinical trial agreements that none of the owners in my company are either excluded or banned or anything like that, either temporarily or permanently excluded. If that's true, I need to know that you guys have a program that evaluates that. Oh, no, we have that covered. Oh, yeah. Can you show me something that says that you guys have that covered? Because I'm not seeing anything yet. Because this is a relationship. People tend to think that in a merger or in a buyout, what you are is a what's the word I'm looking for? Sort of, it's a beauty contest. Yes, it's a beauty contest, but it goes both ways. It's a relationship. And if they're asking you to represent that your site is worth XYZ, that you can produce ABC, you want to make sure that you're enabled to do that. Because you may actually have some targets that you have to hit in the first 1 or 2 years. And depending on how it gets structured, you want to make sure you go, hey, if you screw me on that and I can't meet those targets, that's not on me anymore. That's on you. And if you don't have a program that makes sure that you guys have these compliance elements in there, and I'll tell you, the majority of PE companies don't have a compliance program like this.
Wow. Darshan, you're gonna be in business. You're gonna be in business forever, man. And if you're a PE company going on a buying spree, you should probably invest in this course. You like that shameless plug? But seriously, call me, guys. Or don't call me. Message me. Okay. Number 4, under still Roman numeral 1, which is crazy because it goes to letters, numbers, big letters, small letters. It gets very tricky here. But 4, financial forms, investigator and or institution shall ensure, and I'm waiting for you to interrupt me anytime. So shall ensure, it's actually giving me anxiety. Shall ensure that each investigator and sub-investigator at the study sites provides sponsor with the appropriate financial information for compliance with 21 CFR Part 54. And that they understand.
I don't provide. I provide access. So first of all, let's be clear. Because provide suggests I'm physically giving you something. Access, you come and access whatever I have.
Okay.
Because otherwise you haven't met your burden if you provide.
And that they understand. Yeah. Well, these companies give you all these financial disclosures, no? I mean,
well, it depends on what disclosures they're talking about. So I can't remember specifically, but my rule is I don't ever want to say that I'm going to proactively give you something. I'll give you access to something if you ask for it, but it's not my job to give you things.
Or how about I will comply with something if you
That's fine.
Give it to me.
Well, hold
Or
on.
if you mandate that I do it.
If it's relevant, but yes, if I
Yeah.
deem it relevant, like it's got to
The
stop
words get
thinking of a
tricky, man.
contract as stop thinking of a contract as what the sponsor tells you to do. Think of a contract as what you both agree needs to be done.
Okay. I think that's a good way to
Yeah.
show over, guys. That's that's your advice right there. You don't need the course, anything else. Okay. Number 5, licensing and debarment.
So that's the debarment stuff we were talking about. But keep going.
ICH guideline 4.3.1. If you
Mhm.
all should memorize this.
Yeah, of
Require
course.
that do you memorize that one, Darshan? I'm just
No,
curious.
I don't memorize anything.
4.3.1. Let's go, man. Quick.
I can look it up pretty quickly, but no.
Requires that a licensed physician is responsible for patient care.
Okay,
know you
so
wanna
my
stop
first
me
question.
already.
Well, yeah, exactly. What do you mean patient care? These are not patients.
And we're not offering care.
Exactly. So when I say patient care, first I'd strike that out and go either participant or subject. But keep going.
Chris, I hope you're watching, man. Where am I? Okay, investigator
And now,
or
just to be clear, we're sort of picking this document apart, right? There
Oh,
are
yeah.
things you're going to go at a practical level where you go, "Is this the battle I want to fight?"
right. And I think that's where Chris is coming from in the sense
Yeah.
of let me protect like the most downside I can
Right.
of the site, which is
Right.
he thinks indemnification clause and
And that's not wrong. There are
yeah.
some clauses that are definitely more valuable.
Mhm.
Publication, indemnification, IP. Those are like the most negotiated.
And like the ones most likely to get you in trouble, I guess.
Yeah. But that doesn't mean that there aren't other sections. And just know that
Sure,
you're giving up certain things
sure,
when
sure.
you don't look at them.
Yeah, yeah. Um, and I think most of his time spent on the numbers,
Right.
really. This is why like you two are a match made in heaven, honestly. For our clients, which we refer them all to you too when they need
I know
like
you.
this kind
I
of stuff.
appreciate that. Yeah.
Investigator and/or institutions shall ensure a licensed physician is an investigator or sub-investigator at the study site and shall be
Hold on,
responsible
hold on, hold on, hold on.
for it gets worse.
No, I know, but why is there a licensed physician? I know a ton of NPs and PAs who are the sub-Is.
Uh, but they're licensed.
But that's what I'm saying. I thought the sentence you said is the only physicians can be sub-Is. Isn't that what that sentence says?
Right. It could be interpreted as clinician. I would have done this if I would have actually read this, I would have changed it to clinician.
That'd be fine. I'd be okay with
Yeah.
clinician.
Yeah. But only shall ensure that a licensed physician is an investigator or sub-investigator at the site
That's a problem. But yeah.
and shall be responsible for patient care.
Again, why? What are you defining as patient care? Because I can have an RN doing patient care.
Right.
So an
If-
appropriately licensed, again, I'd use appropriately licensed clinician
Yeah.
shall be responsible for
Yeah.
any of those things. But yeah.
Very good. I agree. If investigator and or institution or any person or organization performing study responsibilities should become unlicensed or disqualified during the course of the study, investigator or institution shall promptly notify sponsor in writing. I think that's common
That's
sense.
fine. The rest of that
Yeah.
that part of it is fine. Yeah.
Investigator and institution agree they are not and have not been debarred or disqualified from participating in clinical research by any U.S. regulatory authority.
The funny thing is, I would make it again if you're trying to be like really really in depth, right? And you won't fight every battle, but
Yeah.
make it bilateral. You sponsor also have to tell me if any of this applies to you, because if you are debarred or someone working with you is debarred, I could have problems.
Mm-hmm.
So why are you not telling me that?
Because they are the big dogs on the
Don't
food
care
chain,
because
right?
I'd be just as a site for working with debarred individuals. The problems are the same for me.
Mm-hmm.
So I don't theoretically you just go, I don't want to deal with, like, you have to tell me if something happens. Now, Likelihood of that happening, super low. The risk matrix, super low. If you're just trying to be an asshole, yeah, you put that in there just so that they go, wait, what now?
Right. But then you might make it harder for you to get your numbers that you want, on the
Exactly.
back
So you
end.
don't fight every battle.
Right.
Recognize that that's something you're giving up, and recognize that that it is an issue that matters. But
Yeah.
on the risk matrix, so what I like to think of is the only issues I want to worry about are where the risk is too high or the risk is too common.
hmm
There will always be risks that are
Right.
low and common, or low and not sort of it's not a big impact. So look for the ones that are high and common.
Referral fees. Investigator and institution shall not pay fees for the referral of patients.
Yeah, that one's easy because that comes into Stark law issues. That goes into who owns the lab. That goes into reimbursement issues. That you take this away from from FDA and you pull it into the CMS world. You also have to be worried in this situation, for example, who's billing for the standard of care, and more often than not, for standard of care. What you're going to land up with is a situation where the state will decide who can do that billing. So some states will say only the doctor's office can do that billing. Some states will say someone can do it on behalf of the doctor's office, but the doctor's office has to get paid for the clinical work that's done. So that goes back to that corporate practice of medicine discussion we were having earlier. So just need to look at your rules in your state.
The next one is so that was it for referral fees, just one sentence.
Yeah.
Section 7 is IRB approval and informed consent. Prior to beginning the study, the investigator and institution shall obtain approval from the IRB for the study and the informed consent document. Investigator and institution shall only use an informed consent document.
Hold on
which
right
has-
there. So the first question is, why is that on the site in the investigator? Shouldn't that be from a centralized IRB? This might matter in the case of a localized IRB if you're a large academic institution.
Yeah, it does say shall only use an informed consent which has been reviewed and approved by sponsor and the IRB.
But look at the first part of that sentence.
Approval from the IRB for the study.
Oh, who's responsible for it? It says site shall do blah blah blah. And why is the site doing anything?
Yeah, prior to the beginning of the study, investigator and institution shall obtain approval.
Yeah,
from
but
the IRB.
how am I doing that?
We do. Like if it's a central IRB, we do. Like they give you a template, and that's where you put in your
But that
specific
means
site
that they
details.
give you the template. That's the point I'm making. So
Right,
you
right,
aren't doing
right.
it; they're giving it to you.
Right, unless you use a local IRB, but we don't.
Are you exactly? Most small sites don't use a local IRB.
Yeah, correct. Even most big sites.
No, you'll see large academic institutions. They have their own internal IRB. That's why this clause exists.
Yeah.
But don't just throw me in because you're trying to get a template contract out there. I'm pulling out the sections that don't apply to me.
Mm-hmm.
So yeah.
Uh,
No one has any questions so far.
they're scared shitless, most likely. Or they're just like overwhelmed, which I kind of am too.
Are you really? This is like normal.
This is why I don't look at these things. Chris, handle it. Make sure the numbers are right. I don't think we agreed to anything crazy. Like you said, the low probability, high probability, that's more what
How do you know probability?
Experience.
So I guess that's the point. So number one, if you're a site that's just starting out, you don't have that experience. So
Yeah.
talk to.
That's why they rely on people like me and you, man.
Yeah, exactly.
And me and Chris too.
Yeah. The other thing you should be thinking of is there's stuff happening in the background that you may simply not know about. And what I mean by that is, there are other lawsuits happening. There are other problems happening. You guys aren't, I assume, looking at what Pacer is saying or what's happening in the court system. Like, one of the reasons we do Fraud Pod is because we go, here's what just happened.
Right.
And like, holy shit, why is this happening?
Right.
All the stuff we're talking about.
And the sites that do want to be like hyper vigilant, I mean, that's where you come in, really.
Yeah.
Um, monitoring and audit access.
Okay.
Interesting. I almost said the sponsor name like 5 times, so I gotta be careful here. I love this sponsor too, by the way. So
I
if
don't
in
doubt
case
that.
I blurted out, I love you guys. Uh, sponsor designated representatives and domestic or foreign regulatory agencies may inspect the procedures,
Stop.
facilities.
Stop. So, first thing is, I would argue, well, a lot of my sites, large and small, have started saying things like, "Look, we're doing virtual auditing for the most part. We now have a requirement that it's all virtual unless you can tell me why you need something on site, because it's extremely disruptive to my site operations for you to come on site. I need to know."
But for the monitors,
Yeah, yeah.
I mean, we prefer
It's a lot of effort.
a mixture. So that's where it's like, for me, this would be a battle I wouldn't even fight.
And that's your choice. I know sites that go, look, we get, because how many studies are you doing right now?
Like 8, but only 3 are enrolling and 2 are in
Right.
startup. So
Yeah. Now imagine if you had 50.
yeah, but we'd have like what, 11 to 12 staff.
Yeah, but
Right
that
now we
means
have 5.
but they're being pulled away to basically monitor these sites, monitor the monitors.
Sure. And you'd
And
have to like stagger the visits to schedule
exactly,
it and yeah.
it becomes a whole thing.
hmm
So it's easier to just go, look, I'll give you all the documents. You
hmm
already have access to the study records.
Yeah,
You
the
tell me what
eSource,
you need.
eReg, especially if we use
Exactly.
eSource, eReg, and all that. Shout out to Creo, they sponsor our CRA Academy.
There you go. So
Uh,
yeah.
okay, may inspect the procedures, facilities, and study records, including portions of other pertinent records for all patients in the
Whoa,
study.
whoa. Including
I was
portions
waiting for that one.
including portions of other study records. I'm sorry, are we signing HIPAA like business associate agreements? Because how are you getting access to my patient records?
I think these big ones make you sign an MSA too.
Oh, I don't care about the MSA. It's the BAA I care about.
I don't think we have that.
Almost no one does, and that's a problem because you're
Okay.
basically giving someone's. It's one thing to give clinical research records. It's
Yeah.
another thing to give patient information where they're not part of the study. Though that information is not part of the study.
Yeah. I'm actually trying to see what we have here. Purchase order, budget,
Wait, why? What purchase order? Oh, I guess maybe for like.
or web invoicing guidelines.
Okay, fine, whatever.
It's
Okay.
just instructions. And
Yeah.
then a purchase order. What the heck is this? Oh, this file's password protected. I can't even open it, man. So, yeah, we have a purchase order.
Okay, so let's assume there are some purchase orders. That happens all the time.
Yeah.
Sure.
Only with the big ones. Okay. Really careful not to mention the sponsor.
So hold on. Let's go back to the purchase orders. What are the requirements around payments? Do you have like how often do you have to get paid, and how quickly do you have to get paid?
This sponsor pays really good.
I wasn't doubting the
and
sponsor, but I'm talking about again. We're talking generalities. I don't even know who the
Yeah.
sponsor is. But most of the time, make sure that you get paid ASAP. I'd even argue that if you
no,
want
no,
me
they
to do
pay
that,
like multiple times a month. It's like the one of the
it's
few
amazing.
that does this. Like, yeah, it's amazing. It really is amazing.
But
Um,
would you agree that most don't?
yeah.
So have something to protect you. When you walked into the contract, you didn't know how awesome these guys would be.
Correct. I just assumed they'd be like everyone else.
Right.
Yeah.
And you're
We'll
waiting
get to that
6
part.
months.
I think we'll get to that part if we make it. I don't think we'll make it, man.
We're not gonna
We're
make
still
it.
on Roman numeral 1, and there are, let's see how
Probably
many.
9 to 12 at minimum. And it might be 18 depending on the
Well,
next
here's
section.
2, 3, 4, 5. That's indemnification right there.
Yeah.
6, 7. You know what I just caught, man?
What's that?
It goes Roman numeral 6, 7, and 9.
See?
They forgot
The deleted
Roman
section,
numeral
yeah.
8. Yeah, I mean,
What
again,
sections they delete and did they matter is the question.
when I read this stuff, because I trust Chris, I'm like, all right, indemnification good, like standard stuff, let me look at the budget. That's really all I look at. And then payment terms, like how many screen fails per rando, invoiceable, like stuff like that. 9, 10, 11, 12, 13. 13 and then the budget.
Okay. So like I said, about 12,
Mhm.
13, and then the budget. That's totally normal.
13 minus 1 that they omitted. So
Yeah.
12. I mean, this could be like a 12-week dissect this contract if you want.
Yeah,
'Cause
we
we didn't
talked
even
about
get
this
through
questions
section
people
1.
wanted.
I think we should do this to promote our course coming up, or it's already out, and just go section by section, man, because there's the only way to go get through this. We're not gonna do this all.
No,
You
no,
know,
we're
I
not.
gotta end it soon. But let's continue what we still have. On all still under Roman numeral 1. So monitoring and audit access. Investigator and/or institution shall provide sponsor with immediate notice of any government or regulatory review or audit.
Within reasonable periods. There's no immediate. If I get the FDA walking through my door, I understand that I have to inform the sponsor, but I will inform them when it's relevant. If their study is being looked at, I'm not going to inform every sponsor I'm working with. I'm going to inform the sponsors whose study is being looked at.
Of the facility related to the study.
There you go. Okay. But hold on. I think I would need to read. Is it the facility needs to be related to the study, or the study is being evaluated?
Investigator and or institution shall provide sponsor with immediate notice of any governmental or regulatory review, audit, or inspection of the facility or processes related to the study.
Okay, so that's good.
And shall provide.
Hold on, but the facility. So it is facility related to the study. So even if they're coming in for a completely different study, under the language, you have to inform every sponsor you have.
If they audit your processes that are related
no. Look at the language. It says facility or processes.
Yeah, related to the study, which is if it's that site, then it's that site.
Exactly.
If they audit another site of yours, though, that's not on the 1572.
Correct.
Yeah. Okay. Yeah, that one's standard. AE reporting. I mean, you might have a field day with this one. Investigator and or institution.
You don't think I'm having a field day with all of them?
Clearly, man. How long does a site get their contracts negotiated with you, man? It'll take like 2 years.
Well, that's the thing, right? So you decide which ones you want to negotiate, and
one of our selling points is 2 to 4 weeks. We'll get our contract and budget negotiated.
I've actually done full blown contract negotiations and got them done in 2 weeks. But it comes down to what the site wants. You'll see some sites who go, I don't want to give up on anything, and you'll get some sites that go, I want to fight every single thing. And
I tell Chris, I trust you, and this is what I would tell you too. I trust you. Just make it happen, and focus on the budget, like the numbers and the payment terms.
Yeah, the thing is, it doesn't matter till it matters. Like, why even bother having a contract if it doesn't matter? The contract sets the terms of what happens when shit goes wrong.
Which in my 20 years, next year's going to be 20 years.
Yeah.
I don't think it's happened anything.
Hold on. So now what does it go wrong mean? Sometimes you have to go back to the sponsor and go, look, here are the terms of the contract. You haven't paid us for this because the term says blah, you've done blah. You need to be able to refer back. So shit doesn't
We've been
mean
paid very late. Maybe we've been lucky. I know sites that have not gotten paid because the biotech went bankrupt.
Correct.
Or they just refused to pay. Yeah, but like maybe we've been lucky, but honestly, like maybe that's why I focus more on the numbers and you gotta have to be selective about what sponsors you take on.
Let me ask you a question. Let's say you got stiffed on $80,000. Would you still kind of go, it happens and move on?
If I knew the risk going in, so I have a very like subjective way of risk assessment on a sponsor. If I never heard of them, I look if they're publicly traded. If they are, is it like a penny stock? I do some due diligence like that, full of like anecdotes and subjective stuff.
Sure.
But I have that risk going in. Like I know I've worked with Chinese sponsors before, and the risk in the back of my mind, we might not get paid. Like they don't necessarily care about. I'm not speaking for you. They don't necessarily care about U.S. law. But that's
so what do you do?
in.
What do you do? And that's my point. So number one, you have the ability to absorb an $80,000 loss.
No, what I would do for those is treat them differently than like a Novo Nordisk, and that's
Sure.
not who this contract is. I'm just
Absolutely.
throwing out a big one. I know Novo Nordisk is gonna pay me.
Right.
I don't know if like Acme Biotech 123 is
Yeah.
going to with a Chinese website.
Yeah.
And so with that one,
Uh-huh.
I don't do much until I start seeing payments. Like, okay, here's my startup invoice. Is it paid in reasonable time?
I
Okay,
would
I'll
ask for
start
money up
screening.
front. I don't know you. I want money up front. I
We
want
do like
retainer
startup,
sometimes.
startup,
Yeah.
startup
Startup fees.
invoice
Exactly.
before I put any patient. All right.
Yeah. Yeah.
Then I'll put one patient. If
Yep.
I'll randomize that one,
Yep.
I will tell them when do we get paid for this.
Right.
If I start seeing that coming through, then it's okay. All right, these guys are legit. Let's just keep going. If I see it's like difficult, I'm telling them I'm not screening more people.
So what I would possibly do in those situations is go, look, I need a bucket of money because they're doing this with CROs, by the way. So when I negotiate sponsor a CRO
Yeah.
contract, the
Yep.
CRO will often say, I want, I'm making up numbers here, $200,000 sitting in a bank in an
Yeah.
escrow account.
That's
I'm
true.
not
Yeah.
until I know that money's there. We're not doing jack shit.
Right. Right.
Hold on. So
We have
Linda.
shout out to Linda, you super fan. Linda, I gotta interview you. I have dissected so many CTAs and requested so many adjustments to the verbatim that remove so much responsibility from them in some sections and place it on the site. Example, I do not allow the site staff to send logs and or forms pertaining to the study unless it is requested in writing and is agreed will be invoiced under a remote monitoring hourly fee. Yeah, we have those too. Sometimes, most times actually, we have CRAs who sit in the monitoring room doing absolutely nothing, I'm guessing.
That says absolutely nothing. But I don't know
Which I know from experience that's true too, but
Right.
we do have fees for all this stuff too. I think
Yeah.
the fees is where the where the fees and budget meet the CTA is where I'm interested in the CTA.
I recognize that. I think contracts are garbage and worthless until they're worth everything.
I agree.
You can write a contract on toilet paper and it doesn't mean anything until it
Mhm.
means everything. And you want that thing gold plated.
Yeah.
And that's why you're not the people who don't worry about the contract. I worry for them not because it matters every single time, but it matters so that everyone knows what they're walking into.
It matters that one time though.
Exactly.
And just because nothing bad happened to me in 20 years,
Yeah.
doesn't mean it won't happen to you in 2 months
Yeah.
if you're a site. Like,
It happened to one of my clients, and the first client they ever had.
Mm-hmm. One of my colleagues too. First
Yeah.
study they had,
Yeah.
they didn't pay them. I actually publicly did a video on that. Romark, stay away from them if you guys know. I don't mind mentioning them. But I didn't work with them, but sites got the blunt end of the stick on that one. Like
Just
millions. We're talking millions.
Dimension here. I am not taking any friggin' bad light claims associated with this, but yeah, I mean,
I already did a video and an article. There's been articles written about it. Like it's public information.
Yeah.
And that's one of the things about this industry is like we got all these companies accountable. All this like secrecy and shrouded in mystery type of stuff is like helping these people operate, who shouldn't be in this business in the first place.
Yeah.
We didn't even finish Roman numeral 1, man. But let me just read the last.
Sure.
So safety reporting. This is for like SAEs.
Sure.
It's pretty standard.
You're gonna say standard. What you should have learned from this is nothing standard.
Well, nothing but everything.
I think intention is standard. Formulation is not.
Yeah.
Here's what everyone wants. Everyone just wants to protect their interests. That's all everyone wants.
Well, sure.
The problem is how much give and take can you do to protect your interests in a reasonable way.
Well, here's one. It's the end of the section, which is right on time. Honestly, this could be an hour, just this particular subsection.
Okay.
Confidentiality information, data privacy, and
security. Don't even touch it because that is so much in there.
I know, but let me just read the two paragraphs.
Sure. Okay. Sure.
Institution, maybe it's a good cliffhanger. Institution and investigator represent and certify. I know you already hate that.
I do absolutely hate that.
I know you by now. Like you are.
Not
I
representing.
could be a
jack
good
shit if I can help
AI.
it.
I could be a good AI for you, except for like the legal like details. But
Sure.
institution and investigator represent and certify that they have the documented information, security policies, standards, and/or
You do not have that. And most sites do not have that. A documented information security policy, bullshit. Almost no site I know has that.
standards and/or procedures in place.
Nope, they do not have that. Don't make claims and representation that you don't have.
We have like a HIPAA thing in our SOP.
No, you don't. Don't say that you're HIPAA compliant. You are not. I guarantee you're not.
I'm not
I'm
going to
just
argue
telling
that
you,
we
don't
are.
even say it.
I'm saying we have a HIPAA thing in our SOP.
Yeah, no, that's not a thing. You can't have you can't have a HIPAA thing in an SOP. HIPAA alone would be like a setup, like a book of SOPs.
Right. Yeah. This is where this like these pods bleed into fraud pod.
Right.
But not limited to, right? Confidential information defined below, sensitive information, or any other special classification of information given.
I just want to be clear that all the stuff I'm saying right now, when I'm negotiating on behalf of the sponsor, you don't throw this right back at me. Because they're just going to be like, you said that we shouldn't agree to this. So how are you going to agree?
Darshan, I watched on Dan's podcast, and they're going to say, well, no more studies for Dan. How about that? And I'm actually reading an AI-generated contract. Yeah. It's not even a real one, by the way, guys.
Okay.
Or it might. Who knows these days? In addition to protected health information and individually identifiable health information.
Okay, so Linda, she says we have HIPAA training certificates. You do not have HIPAA training certificates because HIPAA training certificate. First of all, there's no such thing as being what's the word?
Well, in fairness to her, she's laughing.
Oh, okay, I don't know if she means that seriously or not. I think she means that seriously. She's just saying that people put it out there. Yeah,
I think she's saying we're doing what is reasonably expected of us.
It's not, and that's the thing. If you look at HIPAA's rules,
yeah,
if you say that you're HIPAA compliant and then you ignore them, the rules are much worse on you.
What's one of the biggest? Because I only get 2 minutes. What's one of the biggest?
There are literally hundreds of millions, if not billions, of dollars in privacy claims.
Okay, but what's the most frequently?
Well, everything from you don't have a breach notification policy to you don't actually have control. Most people have some type of IT controls in place. Almost no one has the breach notification policies, and almost no one has the actual SOPs for training individuals. And there's a whole process that needs to happen. And there's a CISO that goes along with it. Almost no one has that. It's a huge process. Don't say you're compliant if you're not. Don't even avoid HIPAA if you can mention it, because it may not apply to you, first of all. And if you do mention it, you stick your neck out, that neck will get chopped. It's not a question of if, it will happen. And just don't put your neck out there.
Can we just roll out with some, that was intense there, Sean. Just some music, guys. Site Owner Academy below. Message me, Darshan. You're going to be a regular, man. We're going to deconstruct this damn CTA.
I think we need to do like a whole, just a training academy piece on this.
Yeah.
I think people will see what it could look like.
Let the music take us out.
See this in 3D. All lights out for me. All lights out for me. Lightning strikes the beat.